These states are committing treachery. They need to be removed from the U.S. immediately. Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. Today's lecture, ladies and gentlemen, is going to be dedicated to this not new, but recently surging in popularity compact that multiple states are trying to partake in to de facto, so in practice, overthrow and be rid of the Electoral College. Now, for those of you who want to know just how terrible of an idea that is, please go read or watch the lectures on Federalist Papers 43, 50, and 68, in which the father of the U.S. Constitution and Alexander Hamilton, the polar opposite of someone who wants a decentralized government. So if there were a founding father that would have been in favor for something like this, it would have likely been Hamilton, where they say democracies are short-lived and end in blood-filled revolutions, which is why they formed a republic, not a democracy, and that the Electoral College is designed to prevent the prostitutionalization, to use Hamilton's own words, of the electorate. Let's talk about the actual problem going on here and just how unconstitutional it actually is. So the problem we have before us is something called the National Popular Vote Compact, which, as it states, this is on their personal webpage, on their advocacy website, published just a handful of days ago, April 14th, 2026, says agreement among the states to elect the president by national popular vote. That's their end goal, provided at nationalpopularvote.com. It says the National Popular Vote Interstate Compact, remember that word, compact, will guarantee the presidency to the candidate who receives the most popular votes in all 50 states and the District of Columbia. It will apply the one person, one vote principle to presidential elections and make every vote equal. They say why a national popular vote for president is needed. The shortcomings of the current system, so they're already presuming there are shortcomings, of the current system stem from state level, quote, winner-take-all laws that award all of a state's electoral college votes to the candidate receiving the most popular votes in that particular state. Because of these state winner-take-all laws, 5 of our 47 presidents have entered office without winning the most popular votes nationwide. The loser of the national popular vote would have become president, but for about 119,000 votes in 2004, 43,000 votes in 2020, and 240,000 votes in 2024. Because of winner-take-all, presidential candidates only pay attention to voters in closely divided battleground states. In 2024, 94% of the general election campaign events took place in just 7 states. That is, 43 states, and 80% of U.S. voters were mere spectators to the presidential election. The winner-take-all method of awarding electoral votes repeatedly generates controversies over real or imagined irregularities and incentivizes hair-splitting litigation. A mere 537 popular votes in one state decided the national outcome in 2000. An average of only about 280,000 popular votes spread over 1, 2, or 3 closely divided states decided the last 7 presidential elections. In contrast, the first-place candidate's lead in the national popular vote averaged 4,327,902 votes over the same period. Currently, every vote is not equal throughout the United States, for reasons including the formula for allocating electoral votes to the states, intra-decade population changes, and turnout differences that increase or decrease the value of a voter's vote. Voters in the closely divided battleground states have an average of 200 times the weight of votes elsewhere in deciding the outcome. Voter participation is 11% higher in closely divided battleground states than elsewhere. Let's see how they claim it actually works. And it's hilarious because they try to cite the U.S. Constitution. You're going to see very quickly and very bluntly how the U.S. Constitution rules this as completely illegitimate and unconstitutional. So they say how the National Popular Vote Interstate Compact works. Winner take all is not in the U.S. Constitution. Correct. It was not mentioned at the Constitutional Convention. Instead, the U.S. Constitution, Article 2, gives the states exclusive control over the choice of method of awarding their electoral votes, thereby giving the states a built-in way to reform the system. The National Popular Vote Interstate Compact will take effect when enacted by states with a majority of the electoral votes, 270 of 538. The candidate receiving the most popular votes in all 50 states and D.C. will get all the electoral votes from the enacting states. This guarantees that the candidate receiving the most popular votes nationwide will get enough electoral college votes to become president. Under the National Popular Vote Interstate Compact, no voter will have their vote canceled out at the state level because their choice differed from plurality sentiment in their state. Instead, every voter's vote will be added directly without distortion into the national count for the candidate of their choice. This will ensure that every voter in every state will be politically relevant in every presidential election. National popular vote has been enacted into law by 19 jurisdictions, including 6 small states. So take note of these because these are the states committing treachery. I'll go ahead and highlight them for you here. 6 small states, 10 medium-sized states, and 3 big states, California, Illinois, New York. Together, they have 222 of the 270 electoral votes needed to activate the law. No, this process is illegitimate. Whatever they're trying to say here, 222 of 270 to activate the law. That's non-existent, non-binding. It is also passed in legislative chambers in 6 additional states with 61 electoral votes. Again, take note of these. These are the states committing treachery. Over 3,900 state legislators have sponsored or cast a recorded vote in favor of it. So here we have an article from Factually, again, here recently, addressing this blatantly unconstitutional behavior by these states. It says, how do state laws like the National Popular Vote Compact create a de facto national popular vote? It says here, the executive summary, the National Popular Vote Interstate Compact uses state law to direct electors to the nationwide popular vote winner, effectively creating a de facto national popular vote without amending the Constitution if states representing a majority of electoral college votes join the agreement. Proponents argue it equalizes every vote and preserves the electoral college structure. Critics warn of legal uncertainty, partisan incentives, and shifts in campaign strategies. So let's read this first part again. The NPVIC uses state law to direct electors, compelling the electors to conduct themselves in a certain manner. How the compact works in plain terms. Under the compact, participating states pass laws that require their electors to cast electoral college votes for whichever presidential candidate wins the national popular vote, and the compact is written to becoming binding only once states totaling at least 270 electoral votes have enacted it. So the compact guarantees that the national popular vote winner would also win the electoral college once activated. The legal and constitutional levers states are using. Supporters point to Article 2. Yes, we're going to look at that. Authority that gives states exclusive control over the manner of appointing electors and argue each state can lawfully change its method by statute to award electors based on the national tally. Opponents and some legal scholars say the pact may implicate the Constitution's compact clause and could require congressional consent or face challenges over whether states can alter the presidential election structure without a constitutional amendment. No. The political calculus behind state adoptions. Advocates have pursued the compact state by state rather than through a national amendment because it would be impossible. Because it is politically and procedurally easier, and because a coalition of state-level laws can reach the 270 vote threshold more quickly than a constitutional amendment process. National Popular Vote and allied groups have spent nearly 2 decades pushing bills across legislatures, winning enactment in many jurisdictions that together now approach the activation threshold, 222 electoral votes as of April 2026 after Virginia's recent addition. What changes and what stays the same? If states totaling 270 electoral votes join, the compact would not abolish the Electoral College. It would simply change which candidate each state's electors are pledged to, aligning state electors with the national popular vote winner rather than the state-level winner. The practical result would be that the candidate who wins the most votes nationwide would win the presidency, eliminating scenarios where the Electoral College winner differs from the national popular vote winner. Again, please go read or watch the lectures on Federalist Papers 43, 50, and 68. The founding generation explained very directly why this is a terrible idea. The arguments for equity and turnout. Proponents say the compact applies a one-person, one-vote principle to presidential contests and would make every vote matter equally, reducing the concentration of campaign attention on a handful of swing states and encouraging turnout across the country. Advocates also point to historical cases, including 2000 and 2016, where the Electoral College result diverged from the national popular vote as evidence of the system's distortions. 6. The counter-arguments and practical concerns. Critics contend the compact could shift campaign incentives toward population centers, diminishing attention to smaller or rural states, and they highlight unresolved legal questions that could produce litigation, possibly reaching the Supreme Court. Some governors and state officials have explicitly warned that binding electors to the national vote could diminish a state's influence in presidential contests. Absolutely. One of the big arguments cited in Federalist Papers 43, 50, and 68. Additionally, opponents note that nearly all member states have been controlled by a single party at the time of joining, raising concerns about partisan motivations and long-term reversibility. The current status and the remaining road to activation. As of April 2026, states and D.C. totaling 222 electoral votes have enacted the compact, leaving an additional 48 electoral votes needed to reach the 270 threshold for activation. No, that standard is non-existent. It doesn't exist. Advocates describe the effort as slow and steady over roughly 20 years and continue to pursue bills in additional legislatures. Which states will move next is uncertain, and legal challenges remain a plausible hurdle even if the numerical threshold is reached. And here we have again their platform, their ideals, their objectives, their movements, which is to de facto overthrow unconstitutionally the Electoral College. So let's see if their arguments have any basis in constitutional reality. And then we're going to show you how the Constitution actually directly addresses this and prohibits any behavior of this sort. So let's go to Article 2 before we address the compact problem. Let's go to Article 2. Here, I'll search up manner. There. Article 2, Section 1. Each state shall appoint, in such manner as the legislature thereof may direct, a number of electors. It doesn't say the legislature can then compel, after they've appointed the elector, what to do. It says a number of electors, equal to the whole number of senators and representatives to which the state may be entitled in the Congress, but no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. That's quite the stretch to make. That this right here, in such manner as the legislature thereof may direct, then allows you to, at whatever extortion, at whatever mandate, compel an elector to behave in a certain manner. What that interpretation requires is for this second portion to be omitted. Each state shall appoint a number of electors. That's the manner that you get to determine a number of electors. Let's talk about the U.S. Constitution that irrefutably makes this treachery. Article 1, Section 10. So I'll show you here. Article 1, we scroll down to Section 10, which is the only part of the entire U.S. Constitution that in any way limits the powers of the state governments. Article 1, Section 10. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, yada, yada, yada. The third paragraph is where we should be looking. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state. Oh, well, Caleb, maybe state isn't referring to the states within the U.S. Maybe that's foreign states. No, because it then immediately says, or compact with another state or with a foreign power, or engage in war unless actually invaded or in such imminent danger as will not admit delay. There is no case, there is no historical backing, there is no legal standing that these states have to justify their unconstitutional behavior, their unconstitutional actions. So they have one of two options. You can stop immediately, stop subverting Article 1, Section 10, Paragraph 3 of the U.S. Constitution, verbatim, it says no compacts between states, and the NPVIC is to make a compact between states, you either stop your treacherous behavior now, or you leave the US. Declare your independence, secede, whatever. But as long as you're in the US, this behavior is treacherous. This behavior is a violation of the US Constitution, and thus cannot be implemented. Now, if you go and get consent from Congress, that's part of the required process in Article 1, Section 10, Paragraph 3. If you get consent from Congress to implement the NPVIC, you're following the US Constitution. But as of this recording, you do not have consent from the US Congress to do what you're doing, to make this compact between the states, which means you are irrefutably, undeniably violating the terms of the US Constitution, which is grounds for censure, grounds to kick you out of the Union. You don't get to have all of the benefits, all of the safeties and securities of the US, and also break the rules and the terms of the US. So choose. Are you going to stop this verbatim, irrefutable, treacherous behavior, or are you going to leave the US? You have to pick one or the other. You don't get to break the rules and enjoy the benefits of having those rules in the first place. So, if you have any questions about this topic, maybe you think I'm totally off my rocker, or maybe there's another legal topic you'd like me to cover in a future lecture, go ahead and post those down in the comments, because the entire purpose of the Calhoun School of Law is to equip you with the necessary skills and information such as this to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope you all have a wonderful day, and until I see y'all in the next lecture for the next topic, I bid you all farewell.